This one. Appeal is allowed as accordingly allowed. Acted.
Deeply.
14. Allowed.
I'm obliged, madam.
Lordship, I will be allowed to further additional affidavit as well as the content application which was filed yesterday with your price.
Please, Your Lordship. And item number 5, madam. I may allow to withdraw, my lord. I am instructed to withdraw money. Item 5, madam.
Item 5.
5.
Mr.
M. Rahman, Mohibur Rahman.
Raman, learned counsel for the appellant, submits that he has been given instructions by the appellant to withdraw the. No. The affair of Mr. M. Raman is allowed. The appeal is dismissed as withdrawn.
Obliged.
Madam. I will mention item number 2 and 3, madam. Need some time to file preliminary objections, madam, for the respondent. Madam. Sir.
2 and 3.
Yes, ma'am.
Central Excise appeal.
Yeah.
For the respondent, madam.
Has it been admitted?
No,
Then
notice was issued.
Do you want to?
your name is?
Yes, madam.
Have you filed wakalat nama?
Yes, madam.
When?
On last occasion, madam. The name is reflected in the cause list, madam.
Huh?
Our name was already reflected in the cause list, madam.
Right. Mr. S. Sharma, learned for the rest that he would like to file a written objection.
Preliminary objection.
Preliminary objection. Accordingly. How much time?
2 weeks, madam.
2 weeks time is granted. This is the matter after 2 weeks.
Much.
Not.
May I please your lordship? Lordship, here I would like the IA for bail, my lordship. There is an IA number 1025, my lordship. The paper book is also ready, my lordship. My lord.
Yes, so you are married? No.
Yes.
No, this is a different case, sorry.
Different. Lordship, informant is also there, Lordship. Others they receive.
Amicus?
Amicus is
Already appeared on
last occasion.
Just the
Yes, my lordship.
Maybe fix for hearing, Lordship.
Lordship, there is an IA. Sorry, I lost the Holiday Society.
Admission or
I say,
let us see the evidence.
yes, my lordship.
Lordship, he will be there, Lordship.
Huh?
Amicus is there, Lordship.
If my case is there, it's okay. If he's not there, what to do? Cannot wait.
My lordship, may I kindly be, my lordship is taking the paper book. My lordship will take the evidence first. That my lordship.
Evidence.
I said, before evidence, can I go 1 to 164 first? Can I start to 164? 164 is page 72, my lordship. My lordship, page 72.
164 of whom?
164 of the victim, my lordship. My victim.
I have been in love with Rabani Ali for a year.
My lordship. Presently, I have been in love with Rabani Ali for a year. Accordingly, on 23/3/2021, I told Rabani over the phone that I would elope with him. I eloped with him because my parents would not allow me to marry him due to the difference in our religions. He took me towards Kohumara and kept me in his friend's house for 2 days. When he went out for work, his father, accompanied by another person, took me to Lilabari police station. After medical check and
Okay, got it.
my lordship, the evidence of
The age of the victim?
victim, as per the 164, she has stated to be 14 years. Page 72.
72. Okay, 14.
At that time, the age of the
Lordship, due
accused,
to ossification test, Lordship, she was 15 to 17 years.
15 to 17 as per ossification.
Ossification.
There is,
Got no birth certificate.
yes, my lordship, I was about this. She got a birth certificate and that birth certificate
Certification done when?
ossification was done on the, with regard to the medical, on the next day. Yes, my lordship, on
31st day.
31st,
Where's my room?
or 31st.
31st 5, 2023. 15 to 17, my lordship.
Page number 21, Lordship.
And the birth certificate, my lordship, is at page
Wait
84.
a minute. Ossification then done on 31/5,
5.
23. 23.
Lordship.
The 164 statement.
No, no, lordship, it was, yes, 164.
164 was done on 21. 21.
21. The ossification. Vernacular, more reason to the question. Vernacular. 24/3/2000. No, my lordship, I'm taking the vernacular for a second, please. Vernacular, come on. 68. It was, my lordship, done on 25/3/2021.
21.
21, the vernacular
There
original.
is a mistake.
Now, original, because I'm going to the paper, the records, 25/3. 25/3/2021,
21/5, 21.
my lord,
21.
my lord.
Okay, that means
Please,
2503. And the 21, page number 21 last.
twenty-five-3 it was there.
25/3/2021, my lordship.
How can it be?
Uh,
Her statement is that is on 33/21. Her statement under 164 is on 30th March. Prior to 164 statement, ossification test was done.
it was not ossification exactly, it was a medical report only, my lordship. It's not ossification. I mean,
But it is written
It is
as
ossification,
ossification test. Page number 21.
How
21.
25/3.
My lordship.
When was the FIR filed? FIR was
FIR, my lordship,
on 24/3.
24/3.
FIR is on 24.
3.
The ossification test done the next day.
Yes.
Ossification.
21. That's all. And
Yeah, my lordship,
And this is a
my lordship, the ossification report.
ossification report page.
Ossification report as page 21, my lordship, PW7 evidence is there.
That is, there's not a report.
That's not a report, my lordship.
There is evidence.
My lordship, as per the, I have, no, my lordship, ossification report is not with me, my lordship. That is a report,
9 in 21 says.
that's serial number 9, but the report is not in my hand, my lord.
I don't think this date. Anyway, so you are 14 years old then.
birth certificate is of in page number 84.
The birth certificate was taken up in the year 2015, my lordship. Birth certificate is at
Page 81.
84, my lordship. It was taken up on 14/8/2025, my lordship. 2015, my lordship.
Huh? Taken out when?
It was on 14/8/2015.
17/8.
Registration date,
17/8, 2015.
date of issue and registration 14/8/2000.
Date of birth is
Issue is 17/8.
5/16, say 10/5/06. That means at that time, he would have been 15 years. 15,
per the birth certificate.
around 15 years.
Lordship.
The birth certificate, my lordship, during the evidence,
How old are you?
at the time of occurrence, 18 years.
You're 18 years.
And my lordship would be pleased to take the evidence of the victim, my lordship.
Yes. Age?
Page PW5, my lordship, page 17. May I read, my lordship?
Say,
On Tagore Party, the informant of this case is my mother. I know accused Rabani Ali. The incident occurred last year. That day, I went for a walk in the evening. I was late in returning home. Since I was late in returning home, my mother lodged an Azahar with the police. Hence, the police questioned me, got me medically examined, and also got my statement recorded in the court. At that time of the incident, I was 18 years old. My lordship, the cross. Rabani neither attracted me nor made me eloped with him. Being our neighbor, the accused is like an elder brother to me. Hence, I went on an outing. The statement made in Exhibit P4, my lord, this is the 164 statement, were made in such a manner as I have been taught by other. My mother lost the Azahar due to a misunderstanding. I did not elope with the accused, nor did the accused.
did you have a baby?
My lordship,
Were you pregnant?
my lordship, she got married. At that time, she's pregnant. My lordship, she got married. The PW1, my lordship.
She was married to you?
No,
I thought
that
some other
some
person.
person.
And 7/12, 84.
That is
51. So another 3 weeks.
done 3 weeks.
Let him spend that 3 weeks. Then we'll see.
There are certain arguments to be made.
Gone.
Lordship would take up this matter at 2 p.m.
No. No, he's got too many matches. My brother has got a lot of single bench also, and I've got also
Lord,
with the chief. I've got with the chief. No time.
Lordship would take it up tomorrow. If
No,
that's
no,
possible.
no. I've got too many men. Right. Though a prayer had been made for taking up the matter at 2 p.m. on the ground that the learned senior counsel for the appellant was on legs in another court, and had inclined to accede to the said prayer, in view of the fact that one of us, back to justice in Kalita, is having a single bench with numerous matters in it. To stop further, one of us, that is me, is having a division bench. Is also sitting in a division bench with the Honorable Chief Justice. After this,
May fix up a date.
accordingly, lead this matter. If after this. What are you? Let me be.
We file an objection now.
Lordship, in this matter, we have received objection from two different PPs. So we are also not sure which objection to be taken into the record. We have got, that doesn't matter.
That doesn't matter.
That
Let it-
doesn't matter. So if the lines which I get to know is that in this PP, it has been mentioned that there are some Supreme Court rules and that 430 should not be mentioned, should not be granted so
lightly.
But the thing is that there is no such as a case law citation which I can see and RUO. In this matter, there is no such things. And in my application, I have stated that I am a 65-year-old lady having a health issues and all. And during the trial, I was on bail.
Let us be very clear once prior to you starting out. Whether you want to have a hearing on it, I want to have a hearing. That was the paper book there. You're ready?
Yeah, I'm ready.
Ready? Okay. Let us have it.
In this IA 644,
Yeah.
I had applied for the suspension of my sentences.
In that other case, consequent, the sentence passed pursuant to the judgment says thereby suspended. In that item. In that, yes,
Yes, we are Anju Khan.
that 15-year-old. No, we have got to suspend. Consequently, the sentence is suspended.
Lordship.
That portion has to be there. Yes,
Here, I have prayed that I am a 65-year-old lady.
yes.
And when I was in trial, actually, since 2009, the order came out in 2025. I was on bail. I have never misused my liberty as such. And now,
Look. The issue is, let us go down to the brass tack. What is the case all about?
this is the case of 302 IPC actually.
And you are the only accused or what?
There were 5 accused actually, but conviction is only of me.
Conviction only of you.
Only of me. It is alleged that I have taken one stick and I have hit on the back of the late victim.
She's your daughter-in-law or something?
No, he was my neighbor. There was a fishing dispute in a Haju, Gaon area. Fishing disputes that came and the allegation is that I have came back. And here also there were some witnesses also which the court had said. Okay, there are some witnesses which are not to be believed, they are executed, and some of them which are to be believed only the PW 3 and 5.
Let us see the finding of the learned lower court. Why you have been singled out.
Lordship, today we are going on the IA part actually.
Correct?
And
Understand as to why only you were convicted. We want to know that.
Lordship, what happened is actually as per the FIR and all actually, that when the victim was coming back after the fight, me, my son, my 2 sons and all, we carried him in front of a school. And while the altercation was there, I took up a stick,
And you hit him.
bit it in the head side actually. And the thing is that in the medical report, it came on the left ear side. In here, it is came on the back side. And when
Doesn't matter, back side, left side, how does it matter? Depends upon your position.
the matter which I want like to just say is that the police had seized 2 things actually, which is can be termed as a water bit. One is a botha. It's a long one, which I have
Botha, what is botha? No,
There is
long one
one-
or short. What is the botha in the first?
There is one thing which used to row,
Okay, say
and
that.
yeah, there was to row. Itself is at 10 kgs. And one they have seized is that, this, when the 2 baskets are there, I also don't know that name. When the 2 baskets, that is also a 11-foot long. But here the stick was only, they say, is a 5 feet long. And the thing is that while the seizure was done, there were some witnesses which they came into the court and have said to the court that both of these was never used at that time. Both of it. They have said categorically that both of them. Now the thing is that there were other sections also, but the thing is that by going by the cross and the PW1, the court has came to know that there were no person had carried him. Only I was the one who had came from the backside and I have hit it. That is the findings of the court as of that day. But at that time also in 2009, it is not possible for me to carry on the botha and this one and hit from
Why
the
not?
backside.
Why not? They are very tough ladies nowadays.
Lordship, this is a fragile lady. In fact,
And how do you know that?
Lordship is true. If I have but the thing is that when the matter is that when all the PW said they had carried it, and later it find out they were all false. So my contention is that if that is false also, and I from the very beginning was screaming that I have never hit him. In fact, what I thought.
So how was he hit? From the bolt, from the blue?
No. Your Lordship said it too actually. What we have said is that while he was coming, he followed upon his head. That was what we have said it actually. And we have and the thing is that during the cross examinations on the doctor also, the doctor said
If he fell upon his head, how do you fall on your head? He somersaulted, huh? And then bang, hit himself here.
Not say it is the backside. This is what we have stated.
Backside, if it's backside, he did not stumble and fall. Either it's the only way someone can fall backside on the back is either he has had a stroke
That is, yeah,
backwards,
that
the
he
back
had,
and something like that.
your lordship is right. We have said that he might be he had a BP, but the doctor has said at that time this stroke was not by the,
How old was he? How old was he?
he was approximately 50 plus, 50 to 50 plus, 55 plus at that time. Your lordship, and the thing is that of my health as of now actually, but the day when I filed this bail petition and all, she was transferred from the jail to the GMC also. I have annexed it in the additional affidavit actually. So her health as of right is not good actually. And the thing is that when we go for this the main one, the appeal, but there are lots of things.
So she's very unwell. She's got a lot of ailments, huh?
Ailment is there. She is a 65 years plus, and the thing is that she's getting treatment at right now at GMCS
For
also.
what treatment for what?
Treatment is lots of old ages.
Sugar, blood pressure.
No, Your Honor, that it's not the thing actually, not the sugar and the blood pressure. But here there are lots of things actually.
Gastritis. What else?
It's normal, I don't think so, because this it has been annexed in page number 18 of this one from the my additional affidavit actually. There are lots of things like which I mean of a 65 to 66 years old woman.
We can know which other diseases is suffering from.
Your lordship, I could apologize that I'm not able to say that what type of uh, diseases she was having, but I have annexed. Then I have also come to know that she is of regular visits to the GMCS as of now itself. This one was just the day when we filed the appeal actually.
When was the impugned judgment passed?
April 2020, this 2025, it was passed on, the judgment was passed on 2/4/2025. And the matter relates to February 2009.
So,
I'm just saying the matter is related to 2009. The judgment was passed on 2/4/2025. Trial was conducted.
when you have been the person to hit him, there are eyewitnesses to the account.
Yes.
Lordship, if I had made it a summary of the witnesses and what the court has felt about this thing. There were 14 of such as witnesses. I have given a summary actually in page number 4 of my this one appeal actually. The PW one was Ramu Das. He was the son actually, and the court has stated that he is not to be believable. It is there. PW2 was Krishna Das. He had executed the facts. He was also not to be believed. PW3 was Mr. Karanga Das, and PW5 was Miss Satyavati Das. These two witnesses has matched what they have said. PW4 was Rasmita. The court says she had also executed what she had saw. PW6 was Dipamoni Das, which the court have said she is partly believable. Partly believable. 7 is Mr. Deepak Das. It is not believable at all. PW8 was Nipu Das, which he said he was absent during the occurrence of this thing. PW9 and PW10 and 11, they are of believable because one is a medical officer, one was never crossed, and PW 11 was nothing such specific about that. 12 was the scissor witness of the Botha and all, which he had himself said ki this was not at use at that time. And what we have seen, because the police had asked them, he was on the road, police had said, he take us to this lady's house. He went along with them. They had seized it, and that's why his signature is there. The whole of the PW 14s actually, only the PW 3 and PW 5. And in the appeal case, actually, I could state that I could be proved that because this 3 and 5 was also not in a very good state, they could have seen these things. PW 3 was milking cow at his house, what he saw. And PW 5 was a relative of the PW 1, Mr. Ramudas, FIR. So out of 14, only out of these 14 PWDs, which the deceased side had gone, only 2 are this one, which the court thinks only 2, the statements are collaborating. Remaining all, except the medical officers and the IO, they are all either not believable at all, or partly believable, or the thing that they have exaggerated what they have seen or what they have not seen.
You see, the evidence of only one witness is necessary.
That's true. That's true. I in my appeal, I would like to state that I could prove that this too, what they have seen is not
Prove it now. This is the time to prove it,
logic. If
not now.
logic, if I may say, because it was for the suspension of the order and for the
Suspension of the order doesn't mean that
Because-
we cannot go into the merit.
no your lordship.
You see, the very basis for suspending a sentence would be if you have got some case, some point, some valid points in the appeal. Now you are with the appeal, your basic case, the 3 and 5 are the only hurdles left which you have to cross
As of now, yes.
as PW 3 and 5. So show us at least prima facie that the evidence of 3 and 5 is not reliable.
Lordship, this 3 and 5, I could do. Lordship, the objection which the government.
Get the objection.
No, I'm just saying.
Clarify.
I'm just saying.
Then we will go to them.
Okay. Lordship, I have some marking in here. 3 and 5 actually. He says when he was called for the cross and all, he said it has been 4 years. 4 years down the lane. And he has said it is in the PW 3. PW, because I am concerned about as per your lordship, it said my main hurdle is of 3 and 5 actually. Because both of the statements are related and honorable court had accepted this thing. He says it has been 4 years and matter is it's beginning at early morning at 8 a.m. He said this Birendas was his brother. He deposed while he was busy milking cow and hearing huge and cry, while he rushed to the place of occurrence near Bhakta school, he saw the accused Meena Das at the rate of Reena Das gave a bamboo stick blow on the back of the head of Birendas on being assaulted. Birendas fell on the road. He deposed Birendas was taken to hospital by PW3 son Krishna Das and others from Haju. Birendas was taken to the GMCS and on the next morning, Birendas expired on GMCH. During cross, he denied that while giving statement before the police, he did not tell about the milking of the cow and rushing out on hearing huge and cry. At that particular point, because he gave this statement after a period of 4 years, But while after this, the police has conducted the inquiry, he never said that he was milking the cow and he had heard huge and cry. He denied and rushing out on hearing huge and cry to the place of occurrence. He denied that the matter of fishing on the date of occurrence, that they had quarrel with Jogen Das, Lohit Das, Kishore Das, and Bhakta Chop. The thing is that he had denied there was not any fishing quarrel of these two families. But
Mr. Constable, is there any, does PW3 have any enmity, any axe to grind with the deceased?
yes, yes, Your Honor, they are all from the same family.
They are from the same family.
All the 14 are all from the same family. They're all from the same family. They have the rights to serve. And the thing is that all the
Relationship of PW3 to the deceased?
he deposed Biren Das was his brother.
Viren Das is who? The deceased
Deceased
was his brother.
brother.
PW3's brother.
Brother. And the thing is that the whole village, whole police officers report everything. The matter began at around 4 a.m. when there was a quarrel of fishing. There is a lake of there because of the nets actually. Because the thing is that on earlier occasions, the net was snatched by these family members. The whole quarrel began at in the midnight of that day. So he said that there was no quarrel, is not justifiable. Everywhere in police, every time the quarrel started at midnight of the fishing incidents. Even if I go to
Well, let us go to PW5.
PW5, Smriti Satyavati Das deposed during evidence that the informant Ramu Das, he is the son of who had expired, is her relative. And she knows all the accused persons, and Biren Das was her uncle's, was of her husband's uncle, Khura. She deposed 4 years back while she was standing in the front of a house near Bhakta Devi's school. She saw accused such and such in giving a bamboo stick blow on the backside of the head of the Biren Das and ran away. She and ran away. Here also, she deposited Biren Das fell down and was taken to the Haju hospital for treatment, and therefore Biren Das was referred to GMCS, and subsequently Biren Das expired on GMCS. She said that. During cross, she denied that while giving a statement before the police, she had not stated that she was standing near the place of occurrence. She was not standing near the place of occurrence. She denied that while giving statement before, she had not said that she was giving she had not said that after giving a bamboo stick blow, Rina Das fled away. She now saying it. She does not know whether after giving the blow that the accusers ran away. He stated that the bamboo stick was about 3 feet in length. Your Honor, it is 3 feet in length. And the seizure what they have done, they are all of 7 foot and one is of 9 foot. Behind this one. Her thing is about 3 feet of length, 3 feet in length. That is the thing. She said 3 feet in length, but that 3 feet of length of any murder weapon as such not been possible. She denied that she had not seen in the quarrel and had no knowledge. She denied that Birenda got injuries by falling on the road. She denied that accused Inada did not give the stick blow on the Birendas, and she is not responsible for his death. Here, this both PW3 and PW5 were the relatives of as of such. Here, the PW5 says at the time of giving the statement to the police, she had not said that she was nearby. But while giving, after a 4 years lapse, she came to the court and said 3 foot long was there. I had not given the type of statement over there. And I don't know if there was any quarrel between those of the things. Families. Whereas These two families have a quarrel long, it's a history of having quarrel between both of them.
So motive is there.
Motive is there. Motive. is
Then
there. Yes, Your Lordship. Thanks for that. I motive was there.
if motive is there, then it's bad for you.
No, the thing is that they are of the
Motive-
same.
If motive is there, it's bad for you.
No, what the thing is that because I cannot hide the fact because there were lots of FIRs between both the families. They have also give all because of the touchingness.
You see, the problem is the eyewitnesses to the crime. And when they said that a woman has eaten up, it seemed quite, it seems that they are telling the truth because usually if it was a false thing, they'd usually blame it on the man. But then after they all blamed it on you.
Lordship, whatever you,
And,
whatever the Lordship is saying,
There's no reason for us to disbelieve that.
Lordship, whatever the court is saying is good. Actually. Only these 3 and 5 was what it is said to be believable thing is that they are the only two who have not said ki all the people said hear out them. Otherwise, whatever they all from the number 1 to number 10, they have said ki this my son, my husband, my in fact the my
Yeah, I think yes, but
Lordship. There are eyewitnesses accounts, 1 to 7 there are eyewitnesses. My learned friend also said there are only 2 eyewitnesses. Even if there is only one, Lordship, it is enough here, Lordship, to convict a person. They specifically in unequivocal terms have taken the name of the this one, accused appellant. And there is motive, it gives like our prosecution is more stronger. And whatever they have stated, it is supported by the medical evidence. Since your Lordship, TCRs have arrived, may I pray your Lordship, may we please to direct the registrar to prepare a paperwork. I don't think they have a good case for Lordship, suspension of sentence.
I think let paper book be made first.
So, whatever the court said, but I could definitely pray for her bail actually. Because going by her past records, also she have never made them for bail.
No, you see, the problem is right now it's a question of a convict. You're
Yeah.
not a UTP now.
No, right.
That is the only problem. I think let the paper book be made.
That's
Then
fine.
okay, otherwise you might not get the result that you wanted.
As per your laws.
You're right. In the main appeal, you're right. As the TCR has arrived, registry to prepare the paper. This is the matter after preparation of paper. Yes.
May it pleases you, Lordship. Here, your Lordship, IA has filed your Lordship, seeking your Lordship bail, regular bail, your Lordship, because criminal appeal jail is pending.
The filing your written objection or what?
I return objection delay. Get it, get, no. No, from our side, no Lordship, it is not filed, we'll have to file. Return objection.
Your Lordship, in the main appeal also, your Lordship, it is a clear show, your Lordship, there is a hearsay, your Lordship, and moreover, there is
There
a.
is no such order that objection, you have filed newly die, no?
Yeah.
She have filed newly die.
Okay. Sir, you filed, when did you file?
After vacation, Lordship, I'll.
Are you objecting?
No, your lordship, because it's their right, your lordship, to give objection. And moreover, the petitioner is behind the bar, your lordship, from 1 year, 4 months, your lordship.
You're going to make up your mind. Either you object.
No, your lordship, I'm
Object.
not objecting it. It's their right, your lordship. Let them file their objection. I have no objection regarding that.
We are still standing for the secondary education department.
Yes, your lordship.
She won't object. It's A. Begum, Learned Addiction PP. Is granted a further
5 weeks. Lordship.
Your
I-
lordship,
no,
2
no.
weeks may be granted, your lordship. Kindly please, your lordship,
Lordship,
because
My learned friend knows Lordship. Now vacation will be started, Lordship. So I will be also.
after reopening of the, your lordship, vacation, your lordship, any date may be given. A date may be fixed, your,
it is granted 3 weeks time to file
a date may be fixed, your lordship.
matter on 23rd, 23rd,
23rd.
23rd October.
I'm deeply
Lordship.
obliged.
And the paper book has been made, no?
Lordship, maybe.
So we can decide the entire case.
Yes, your lordship. For that also, I am
Prepared.
ready, your lordship. I am prepared.
And we can do it now also,
Yes, your lordship.
but you're not prepared.
After vacation. Lordship.
Yes, your lordship.
Okay.
Deeply obliged.
But say appeal against the order passed by India court.
To issue notice or
But
what?
yes, but there's a delay, but
Received the copies.
So you have to file it now or you have to.
We
you
have
have-
not received the copy to you.
Oh,
I'll supply
42 days.
40 days.
Any objection?
Lordship, let us first receive the copies. Then notice
Okay.
may be issued in the.
Now we issue notice now. You give a copy now.
That's not I'm giving.
So you want some time?
Yes, Lordship.
Okay. Mr. N.J. Datta, Learned Counsel for the applicant submits that there is a delay of 42 days in filing the appeal against the denial of bail to the applicant dash appellant by the NIA court. Mr.
D for the judge.
D. Bardwaj appearing for the NIA, prays for 3 weeks time.
Yes, Lord.
3 weeks time. For what? To file WO? No. Prays for 3 weeks time to listing of the matter,
Yes, Lord.
to enable him to make his
In the
submission,
meantime, I will get the instruction.
to enable him to get instruction. List the matter after 3 weeks.